I've been asked to give you a presentation about employment or employees versus independent contractors. So I'm going to go through 5 topics. I'm going to discuss how do employees and independent contractors differ? What are the consequences if you misclassify a worker as an independent contractor? What's the test to determine whether a worker is an employee or an independent contractor? I'm going to briefly touch upon a third category of worker, which is a dependent contractor. And lastly, I'm going to provide some practical tips or helpful tips for hiring independent contractors that hopefully help avoid some of the pitfalls that you can fall into. So the main difference between an employee and an independent contractor is that independent contractors are obviously in business for themselves. And this results in different characteristics between the different types of workers. So employees usually only work for one employer. Their work hours are set by their employer. And they usually work out of the employer's place of business. While an independent contractor can provide services to more than one business, they can set their own hours, and they often work out of their own office space, depending on the nature of the contracting work. An employee is under the control and direction of the employer, so generally an employer sets the assignments and also determines how the employee is going to complete those assignments, while an independent contractor is relatively independent. They have the authority to decide how to complete a task and how that task should be performed. An employee, when they perform a task, they don't generally incur any costs. Obviously, the employer incurs those costs for performing that task, while an independent contractor can incur costs and expenses for performing the work. Another main difference between an employee and an independent contractor is that employees are covered by provincial employment standards legislation. So in Alberta, the key legislation is the Employment Standards Code. And the Employment Standards Code just sets out the minimum obligations that an employer has to provide its employees. You can't contract out of the Employment Standards Code. Even if your employee is agreeing, neither party can contract out of the code. And the types of minimum standards that the code sets include the requirement to give employees vacation time and vacation pay. Employees are entitled to general holidays and general holiday pay. They are entitled to a minimum wage. They get overtime. They have certain restrictions in terms of hours of work and rest periods. Employees get a number of job-protected leaves. They also set out the type of minimum termination notice you have to give an employee. And the code also sets out record keeping that an employer has to maintain. This is a stark contrast to independent contractors who don't get any of these minimum obligations. They're paid in accordance with the terms of the contract between the contracting parties, and they're not entitled to any of the employment standards minimums. Another key difference between employees and independent contractors is workers' compensation. So employees will receive workers' compensation benefits if they're injured on the job. And workers' compensation is a no-fault insurance for workers who are injured on the job. And workers' compensation legislation requires employers to pay annually an assessed amount into a common fund, and from that fund, employees who are injured, their benefits are paid. And this coverage is mandatory for most industries. Alternatively, workers' compensation works a bit differently for contractors. So if a company hires a contractor or a subcontractor who doesn't have workers' compensation, they could be responsible if that contractor or one of its workers are injured. So the code, the workers' compensation legislation makes 2 distinctions between contractors who are not incorporated and contractors who are incorporated or have a corporation. So if a contractor is not incorporated and they don't have workers' compensation, your company will be obligated to provide workers' compensation to those employees and to report any labor portion of the earnings as insurable earnings. If a non-incorporated company does not have workers' compensation, if a non-incorporated company does have workers' compensation, you then don't have to provide that coverage. However, if that contractor isn't paying its workers' compensation premiums, you could be liable for failure to pay for that contractor for not paying its premiums. So you want to make sure that you get a clearance certificate or a clearance letter from your contractor confirming that their premiums are up to date and they're paid. And ideally, you would ask that before you make your final pay, so you have some money that you can potentially pay those premiums from. So you want to be careful on that front. And just to back up for a second, a non-incorporated contractor is going to include like partners, trade name companies, and sole proprietors, so people who own or operate a business and they don't have any workers. If a contractor is a corporation and they don't have WCB coverage, you don't have to provide that coverage, but if directors of that corporation don't have personal coverage, you're not protected from any lawsuits if a director is injured. So again, you want to request confirmation from the contractor that they have an open account, and again, you do that by getting a clearance certificate. If a contractor is a corporation and they have WCB coverage, again, you don't have to provide that coverage, but you could be liable if the contractor isn't paying its premiums or if the director does not have personal coverage. So you still want to make sure that you're getting confirmation that your contractors have WCB and to request a clearance certificate.
Okay, so you use two different terms there. What is the difference between a contractor and a director in this
So,
context?
so when I say director, it's a director of the corporation. So corporations have directors.
No, I get that part. So you're actually saying the management does not have appropriate
Yeah.
coverage, but what about so they would have employees, for which are the ones that are going to be fulfilling their contract. So, I mean, where does the liability lie? Just with the directors?
Yeah, so if the company is incorporated and they don't have WC, where your liability lies is in respect to the directors. So if the directors don't have personal coverage, they can still sue you.
Yeah.
I'll get into this later on, but it is really important when you're entering into agreements with contractors to make sure that they are acknowledge and agree that they're responsible for getting workers' compensation coverage, and also have a term in there that you can request at any time a clearance certificate. Because really, at the end of the day, that is, if you want to ensure that there's complete protection, you want to make sure that they know that they have WCB and that you're asking them to get that WCB, and that you can ask for that proof at any point. Another difference is employers have to withhold income tax, CPP premiums, and EI premiums from employees' wages. You don't have to make these withholdings from earnings paid to independent contractors. They're responsible for making their own tax deductions and remitting it on their own tax returns. Another difference is employees often receive additional benefits, so they often are participating in group health and medical plans. Independent contractors don't receive these additional employment benefits. Employees also have additional protection from discrimination under the Alberta Human Rights legislation, and specifically Section 7 of the Alberta Human Rights Act protects employees from discrimination and harassment in the context of employment, and the same protection does not exist for independent contractors.
What do you mean by that? Do you mean a contractor, independent contractor can discriminate you and not hire you? What does that mean by they're not protected by Alberta?
So if you were discriminating against someone on the basis of them being an independent, like if an employee is, either they are seeking a job, or they are, or in the context of working for an employer, employees specifically have protection. But an independent contractor does not have that legislated protection that says you can't discriminate against an employee. So an independent contractor does not have that additional protection. Does that make sense?
But they could probably still bring a suit if they were discriminated against, but underneath some other vehicle.
Yeah, like they could maybe bring a civil claim,
Right.
but they wouldn't have the protection of the act. and all the benefits of the act, because it's a very streamlined process to bring a human rights complaint. And really, it's just a matter of filing a complaint form, and then the commission will take over and they manage the complaint. An individual doesn't really even need a lawyer to bring a complaint. So it's obviously a key difference, because you're going to get a lot more complaints when you have the ability to, use human rights and go through human rights legislation. So we've gone through some of the key differences between an employee and an independent contractor. If you improperly categorize a worker as, an independent contractor, this can lead to significant liability and significant risk for a business. So finding that a worker is an employee will trigger certain statutory rights and obligations, as well as common law rights and duties to that worker that you wouldn't have to provide to an independent contractor. Misclassifying an employee is often compounded by the fact that you don't become aware that there's an issue about their classification until either a statutory body is auditing you, such as Canada Revenue Agency, or there is now a dispute between you and the worker, and the worker is seeking additional benefits that they didn't receive as an independent contractor. And another factor that can compound is that, because even if you're having just an individual complaint with one contractor about their classification, this can often have consequences for your other workers, so it can compound the problem if you find out you've misclassified a worker. So some of the key risks or consequences of misclassifying a worker as an independent contractor is, as a business, you can incur penalties, fines, and liabilities. So you can incur penalties, fines, and liabilities for not remitting income tax, not remitting EI premiums, and CP premiums. You can also incur fines and liabilities for not making your worker compensation premium remittances for the workers, and you can also be charged fines and interest for failing to remit those premiums. You may owe the worker back pay, and you also may be liable for penalties for violating employment standards legislation. So if you have been paying someone as an independent contractor, they won't have been receiving things like vacation pay, general holiday pay, overtime. So if they're then found to be an employee later on, then you are potentially responsible for that back pay for not paying those amounts during their term with you. It also triggers common law rights for wrongful dismissal. So if a worker is found to be an employee, this can trigger an employer's common law obligation to provide reasonable notice or pay in lieu of termination. So common law just means it's court-made law or judge-made law that has set what type of notice you have to give an individual that you're letting them know that their employment ends. And if you don't give them sufficient notice, you can pay them the equivalent in wages. So you can give them pay in lieu of that notice. And this obligation for common law notice can be very significant. It's assessed on a case-by-case basis, but the key factors that are examined are the employee's age, how long they've been with you, their position and responsibilities, what their compensation is, and what is the level of available alternative employment when they're terminated. And just to give you an example, this common law notice can range from anything to a few weeks to all the way up to 24 months if you have a long-term employee, an employee who's more senior, and so forth. So the liability of wrongful termination or wrongful dismissal damages can be very significant. So now that we've gone through some of the significant consequences of misclassifying a worker, I now want to take you through the test of, okay, well, we know there's differences now, but how does the court actually assess whether someone is a worker or an independent contractor? So the court applies a two-step process, and the first step is they ask, what is the subjective intention of the parties? So that just means, how do the parties describe themselves? So for example, is there a written contract between the parties where they have described themselves as independent contractors? They also look at the actual behavior of the parties, so is the worker invoicing the company? Do they have a GST registration? Are they making their own tax returns? So they'll first look at the subjective test, but the issue is that even if the parties are describing themselves as an independent contractor relationship, that's not determinative, and the court's then going to look at objective factors, so factors outside what the parties believe to be the case to see, well, no, are they really an independent contractor or an employee? So that's step two. So step two is looking at the objective reality of the parties' relationship, and to do this, there's four key factors that are considered. The first is the level of control over the worker's activities, whether the worker is providing their own equipment, whether the worker can hire helpers to complete the task, whether the worker is managing and assuming financial risk and also has an opportunity to profit by performing his or her task. So the first factor is control of activities. Generally, the more an employee or the more an employer controls the manner in which a worker is carrying out their duties, the more likely that worker is an employee. And this is based on the presumption that independent contractors are bringing their own expertise to a task, while employers generally, and this is a generalization, generally are completing their activities as directed by the employer. Other factors that are considered when assessing who controls the worker's activities is whether the worker can set his or her own hours. Again, are they working from their own business or office? Do they work independently of the employer? And do they determine how they're going to complete the tasks that have been assigned to them? The second factor is equipment or supply of tools. So typically an employee is going to receive tools that have been supplied by their employer. And in converse to an independent contractor who is normally going to provide their own tools. An independent contractor doesn't have to have all the tools they need to complete a task. Generally what courts will look at and say, well, does that worker own the tools that you would expect them to own for their trade? So if there's a specialized tool that the employer or the company has to provide for them to complete the task, that's not going to necessarily make them an employee if you can show that overall they own the tools that they generally need to be in the trade that they are in. An independent contractor can also hire helpers to assist them in completing their tasks. They can also subcontract their tasks to other third parties. An employee, in turn, cannot subcontract their tasks and activities to third parties. And then the last factor that courts consider are financial risk and the opportunity to profit. So an employee generally receives a salary, and that's it. So if the task isn't profitable, they still should get their salary, but if the task is very profitable, they're not going to benefit from those profits. While an independent contractor who is in business for themselves will experience profits and losses in performing a task. Further kind of factors that are often considered when determining who is bearing the financial risk and the opportunity of profit include the ability of the worker to use their own judgment to decide whether they should even accept the work and perform the work. Can the worker accept work from other sources in addition to that one company? Do they have the ability to negotiate contract prices? Is there an absence of a set time in which they have to complete the work? Because this would relate to the fact that if you're more efficient, you could potentially have more profits. Again, can they hire helpers? They'll also look at who's responsible for defects if the work is done improperly. Is the worker required to return and correct any defects at their own cost or expense? And also, is there a guarantee of work from day to day? So if there is no guarantee, or there's no guaranteed minimum pay, and there's no kind of benefits, these are all going to suggest that the individual is an independent contractor. So the majority of this talk has been about employees and independent contractors. But just to make everyone's life difficult, the court has recognized a third category of workers, and that's the dependent contractor. So a dependent contractor has a hybrid status between an employee and an independent contractor. So generally, a dependent contractor has a long-standing relationship with the other contracting party, and they often have an exclusive relationship with each other. The primary significance in finding that someone is a dependent contractor is that dependent contractors are entitled to reasonable notice of termination like an employee would be. And so just to give you an idea of how significant that can be, in a recent case in Ontario, the court awarded a dependent contractor 26 months notice. So this is 26 months pay. Having someone classified as a dependent contractor can have significant financial consequences for a business. To determine whether a contractor is a dependent contractor, courts will look at three factors. So what is the duration and the permanency of the relationship? So the longer the duration of the relationship, or the more permanent it is, the more likely they are dependent. What is the degree of reliance and closeness between the relationship? The more that these factors are connected, the more likely that they are dependent contractors. And this also includes like what percentage of the work or of that contractor's work is solely for that one business. So if it's a significant percentage, this is going to suggest that they're dependent. And this ties into the third factor, which is degree of exclusivity. Pitfalls of hiring a worker and classifying them as an independent contractor is I'm going to now kind of take you through some practical tips to help protect yourself if you are hiring workers as independent contractors. So the first is just kind of common sense. You can limit your exposure by limiting the control that you're trying to exercise over the worker completing their job. So you're not telling them how to perform the task, just that they have to perform the task. You're not setting the hours when they necessarily have to complete the task, where they have to perform the job, or whether or not they can work for anyone else. So those are kind of practical tips that just limiting the control that you're exerting over the worker. But the key way to really protect your interest is to have an independent contractor agreement. So I would always recommend that if you're going to enter into a agreement or a relationship with an independent contractor, that you get legal advice and a legal assistant to make sure you have an enforceable drafted contract, because there are ways where you can fall into pitfalls, and just because you just don't know where you can go wrong. But I'm just going to kind of outline some of the important terms that you should have in any contract or agreement. So firstly, you want to define the scope of work. So what are the tasks that the contractor has been hired to complete? You want to define the relationship. So you clearly want to state that the worker is being hired as an independent contractor, they're not being hired as an employee. You want to clarify that the contractor is not entitled to any benefits or privileges that you would normally give your employees. You want to clarify that the contractor is going to be responsible for any income that they receive under the agreement, and that they're going to be responsible for including it on their income tax returns. You also want to make sure that the contractor secures any relevant insurance policies in terms of completing their work. So examples of the type of insurance that you may request your contractor obtain include like general liability insurance, automobile liability insurance, and workers' compensation. So you should make sure your contractor is agreeing and acknowledging that they're going to maintain workers' compensation, but also that they're going to provide you proof. So even if someone says, yeah, I've got workers' compensation, you want to make sure that you're getting the actual proof and they're providing you with the clearance letter or the clearance certificate to show, yes, they have paid their premiums and yes, they have a workers' compensation account. You also want to set out how the contract can be terminated. So for example, if you're terminating without cause, You can have a clause that says, within, for example, 30 days notice or written notice by either party, the contract can be terminated. You can also say a contract can be terminated immediately without any notice if there's cause to end the relationship. Cause includes generally like significant misrepresentation, fraud, a significant breach of failure to perform duties. So it's a high level, but generally you can define that in your agreement so there's certainty and there's no dispute if you want to then act on a termination for cause. You can also put in provisions to protect your confidential information. So if this contractor is going to have access to your confidential information, you want to make sure that they're acknowledging that information is yours and they can't use it or disperse it to other parties or other clients in the future. We talked about the fact that saying you're an independent contractor isn't always good enough. So even if you have an agreement that says, hey, we agree we're independent contractors, if all the other factors don't support that, you could still be in trouble. So one way to protect your however, I would be happy to answer any questions that you have.
So, if a non-profit hires a contractor, do they have to pay them a vacation? They don't have to pay them a
No.
vacation.
If they're an independent contractor, they aren't entitled to vacation.
Or can the contract specify that nevertheless?
Yeah, so,
So if they say, I want that in the contract.
well, you can always, like, a contractor can always negotiate
Yeah,
what they want. I don't think I would ever recommend classifying it as vacation, because now you're starting to look like
Look like
an
an
employer.
employer, yeah.
But I think the alternative to that would be say, we're not gonna pay you vacation pay, but we'll pay you slightly more
yeah,
in your,
yes.
if that's what you wanna do.
That's what I was thinking.
Yeah, and we normally have in all our independent contractors a clause saying, hey, you're not entitled to vacation pay or overtime pay or any of those types of benefits that we would normally pay our employees. And if you have employees, you're responsible for making those payments. So that's, and we're not gonna be making those on behalf of your employees either.
So if the nonprofit hires the helper, then the contractor, so then the contractor starts to look like an employer, right? So if the nonprofit hires a helper
Mhm.
and the contractor, that can't be done, right? Because the contractor is supposed to hire the helper themselves.
Yeah, like if you're hiring the helper, you are now have the relationship directly with that helper, and
Mhm.
they're either gonna be an employee or an independent contractor.
But will that reflect on the nature of the contractor?
No, the independent contractor, because they haven't hired that helper, is not going to be a factor in consideration, and if anything, it might favor them being considered more an employee if you're
Yeah.
providing the people to help them. It, it
Okay.
starts to get a little bit messy.
Thank you.
You're welcome. Yeah,
Will you send us this?
I don't know what you guys normally do.
You can, if you send it to me, I can post it on our Moodle. Are you in our Moodle?
Yeah, that'd be fun.
Okay. Any other questions? Yes.
So are you saying that with regards to dependent contractors, the only benefits they get is that they're entitled to notice, but they're not entitled to vacations or anything else?
No, it's so the key factor is that they get notice. And the reasoning behind it is that the courts have recognized that, okay, maybe they aren't employees, but they have had such an exclusive relationship with that company that we think it's unfair that you can just terminate them with very little notice. So they've given them this common law notice. And it can be very significant. It's a bit of a strange hybrid entity. I think it was created in situations where the courts couldn't find someone as to be an employee, but they felt that these individuals deserved something more, so they said, okay, we're gonna give you common law, basically common law notice. Yeah.
I was recently looking at some case law about this, that, well, not the case law itself, some summaries, but anyway, that suggested that these definitions are becoming blurry now, because there's been a few cases where people have been deemed by the courts to be contractors in spite of the fact that the employer organized the work, gave them the tools, they were the whole kit. There was like a trucking company situation where, yeah, like the truckers were deemed to be contractors in spite of the fact that they were driving somebody else's truck. The truck owners were organizing the work, all this kind of stuff. Are you familiar with this, or is this like?
Well, I'm not
yeah.
familiar with the specific case that you're
Okay.
referring to, but I can
Yeah.
tell you, like, overwhelmingly, the case law still applies these tests, and
Yeah.
they're coming from like a Supreme Court Canada case, which has kind of the ultimate authority. I am aware of like one case in the tax realm where a court said, I think that you're independent contractors because you've agreed that, but that's kind of the one case in a tax scenario. So whether that would be applied to determine whether someone would be entitled to notice or common law notice, and that's where the majority of the disputes arise in terms of civil litigation. They're fighting over, well, I should get notice,
I see.
and I'm really a worker. So in that area, the law has really consistently been the factors that we kind of set out, and it comes from like SAG-GAZ, I believe is the case, the GAZ. But I understand your point. You can never be, the fact of the matter, the minute you go in front of a judge, my view is that everyone's at 50-50, and you never know what that judge is gonna decide based on what he ate for breakfast that day or whatever. Like, you never know. But, you know, these are generally the principles that still are the kind of key fundamental principles in assessing whether a worker is a contractor or an employee. But I do know of at least one case, and that was only in the context of CRA and a tax assessment, where the judge, and I don't know if that case, it's recent, so it might even be appealed, whether I only know that case where the judge said, yeah, you probably wouldn't have been based on these factors, but I think you guys agreed to it. But that's one case that is kind of a new development, so whether that becomes the new trend, it requires a lot more time to consider, to see whether if the courts are gonna start leaning that direction, because it's kind of just one outlier case, and there always is those outlier cases that you can always find to kind of pull up an alternative position.
So, the dependent contractor versus an employee, that line seems to be razor thin, almost, or am I missing something?
What do you mean by razor thin?
Well, basically, the employer is directing all the work, you're solely working for this employer for a very long period of time, and then somehow there can still be a contractor relationship. How is that distinguished?
Well, they're distinguished probably in the fact that they're probably incorporated companies. That's another key thing. If you want to help protect yourself, ask your worker to get a corporation. That's a good way to protect yourself as well. It's not, none of these things are going to be determinative, but that's one way you can do it. You can say, hey, go and get a corporation. You know, they kind of look at the factors in terms of, you know, control, performance of work, where it's going to be done, but then they also look at the exclusivity. So you could have a situation where I'm an independent contractor, I work out of my office at home, I'm doing some type of, you know, online contracting work for you, or I'm doing your IT services, but I've always worked for you, I'm exclusive to you, you put a clause in my contract that says I can't work for anyone else, so you can see how that person is still a contractor, but the court said, well, I think they're a dependent contractor.
But at that point there, I would almost want to call them an employee, right? Well, like.
Well, no, because
without
every-
the incorporation being in the way is the only real.
Well, no,
distinction.
because I'm saying they could be working out of their own offices, setting their own hours, they're kind of your IT specialist, but you work exclusively for you. So you still have those contractor elements, but the really key difference between an independent contractor and a contractor is the exclusivity and the fact that, you know, I primarily work from you, almost 100% of my work, or even 100% of my work is, you know, from you, you're the sole source of my income, so that's where you kind of get the dependent contractor status.
You see this in forestry a lot, the dependent contractors, where you have mills that would just directly award certain jobs to contractors, and they always give them, say it's, I don't know, logging, they'll always give it to Joe Blow Logging, even though he's a contractor, but they always give it to him because of, long-term relationship with quality of work and stuff. So Joe Blow is still a contractor, but he always gets that contract with that mill. I mean,
Any other questions?
Payment wise, if you are an independent contractor and you choose to, you know, you figure you can live on $3,000 a month and your GST number is grossing $7,000 a month, how do you pay yourself out $3,000 a month? And, you know, you can bank $4,000 into the, how does that accounting work?
Well, I'm not an accountant, so, I'm probably not the best person to ask about how, the best ways a independent contractor should manage their money or, you know, manage paying GST, paying themselves. So I don't have any expertise on that, but, you know, someone like an accountant probably is a better person to, be able to provide advice on that point.
I'll call my accountant. Thank you.
You're welcome.
Any more questions?
Well, can everybody join me in thanking Allison for coming in today and sharing her knowledge? I will post her presentation on our Moodle, and if you're not on our Moodle and you want to email me, then I will, get it for you. And don't forget that we have a few fun events coming up next week at the Canada Business, and 8 drivers to the value, increase the value of your company as well.
Okay, thank you. And you're welcome, and I'll just hang around for like 5 minutes if you wanna, ask me any other questions.